Thank you. You may be seated. So I know who he is. Can you tell me who the two of you are?
Ken Houghton.
Thank you, Mr. Houghton. And you're just with Ken?
Yeah, Tim.
Kim and Tim. All right. First case I'm calling the 2 o'clock docket. It's pretrial for Mid-Michigan Medical versus versus Charles. This is file 21-08791GC. Counsel, identify yourself for the record.
Good afternoon, Your Honor. Barbara Satorova on behalf of plaintiff.
Okay, do we have the defendant here or anyone who could be associated with the defendant? Katrina, is there anyone else in the virtual waiting room?
No, Your Honor.
I don't see any name matching up there, Your Honor, on the participants.
Well, this is the time and date set for pre-trial. It doesn't appear that the defendant has appeared. Michaela, did we get an answer filed in this case or not? Looks like we must have, otherwise we wouldn't have done the pre-trial.
Yes, Your Honor. Back on 6-9, I did just see somebody walk into your courtroom. I'm not sure what his name is.
No, I think you're here, sir, you're here for the Inglis Howden case. Yeah, nope, that's not them. So I will, and then the other person is an observer, not person who, and not the defendant. So we can issue a default at this point in time for the defendant failing to appear. Have you a prepared judgment?
Yes, Your Honor. Did you want me to send in a proposed judgment under 7-day or?
Yes, under 7-day, if you would, please.
Yes, thank you very much, Your Honor.
We'll be adjourned on that case.
All right, thank you.
Next file is the case of Citibank versus Susan Tompkins. This is file 21-09078GC. Counsel, please identify yourself for the record.
Yes, Your Honor. Joseph Jamal on behalf of the plaintiff, Citibank.
And do we have Tompkins? Susan Tompkins looks like is muted. So if you could unmute yourself, please, and identify yourself for the record.
Yes, I am Sue Tompkins.
Okay, today's time and date set for this pre-trial. Ms. Tompkins, are you planning on hiring an attorney or are you planning on representing yourself in this case?
Representing myself with my
Mr.
husband's
Jamal,
help.
Okay, Mr. Jamal, do you mind if I explain the process to Ms. Tompkins so she can understand what she's looking at going forward?
Definitely not, Your Honor.
All right, Ms. Tompkins, I won't presume. I'll ask you: Are you an attorney?
No,
Is your husband?
no,
All right. Do you mind if I kind of explain how the process works so you can understand it a little bit better?
sure.
You've been sued by someone who says you owe them money. Citibank says you owe them money. And there's two parts to that case. There's a part of, do you really owe the money or not? And then the other part is, can you pay it? Sometimes people say, hey, I owe the money, but you may as well just squeeze blood out of a tournament. You're never going to get the money. I'm really bad financial shape. Well, those are two different questions, whether you owe the money or whether you can pay the money. This part of the case is all about whether you owe the money or not. And so my job as a judge is to see the case through to completion. And there's three ways the case goes away. Mr. Jamal, I'm going to ask you a question in 1 second. So if you can unmute yourself, and then I'll have you remute yourself afterwards. First way a case could go away is Mr. Jamal's client says, you know what, not worth it. I'm just going to dismiss the case. Mr. Jamal, is your client planning on dismissing the case at this moment?
They are not, Your Honor.
All right, you can go back on mute. So second way a case goes away is if the parties make an agreement. Maybe you come to an agreement and you say, I can pay you a smaller amount of money right now, or I can pay you the full amount of money over a long period of time, but you come to an agreement. That's the second way a case goes away. Third way a case goes away is if I decide the matter. And I can decide the matter two ways. There's two ways of that last one. One way I can decide the case is what everybody thinks of as a trial. That means that we would have witnesses come in and exhibits and that type of thing. And then I would listen to that. And I would ultimately decide whether or not you're the person who owes the money. And if you do, and how much do you owe? Another way I could decide the case is by motion. Judges don't just do things on their own. Typically, they have to be asked to do it. And how you ask a judge to do something is by motion. You remember probably is when you were a kid, you played a game, Mother May I, you couldn't do anything until you asked Mother if you could do it, right? Well, both sides have an opportunity to ask the court to do something. And I want an order. I want an order to end the case. Well, there is a motion, which means a request to ask the judge for summary, meaning quick, disposition, meaning ending. I want a quick ending to this case. And either side can file one. Mr. Jamal, on behalf of the plaintiffs, could file a motion for summary disposition. That's its name. Or you could file a motion for summary disposition. And essentially, there's a number of different kinds, but the most common ones are, look, Judge, there's no dispute regarding the facts of this case. I should just win as a matter of law. A lot of times the plaintiffs will file one of those. They'll say, you know what, Ms. Tompkins says she owes the money, she just can't pay it. We should at least win the first half of the case. We may have to try to collect it, but we should win because she says she owes the money, she says she can't pay it. And so we want a motion for summary disposition saying we can at least try to collect it. Because right now, all they're doing is filing the lawsuit. You could file one. If you, let's say you have an evil twin sister, and if you have a twin sister, I'm not trying to disparage her, but we'll just call her Peggy. And Peggy knows everything about you, and she took out this loan, and she took out this money, and she's told everybody, including Citibank, it was me. I did it. And you got a piece of paper with her signed under oath, an affidavit, maybe even blood on a thumbprint, and she's going to take responsibility. Well, then you could file a motion for summary disposition saying, there's no doubt about it, the debt's owed, but it's not me, and I've got another person that's claiming that. So that's a type of thing that you could file. So both sides could file a motion for summary disposition. Almost all cases get decided by a motion for summary disposition or by agreement of the parties or a dismissal. Trials are pretty unusual. So what the courts do is we set out enough time for you to try to talk with the plaintiff, in this case Citibank, to see if you can reach a resolution. And we check in with you about 3 months out. And if you can't reach a resolution, then I'll decide the case whether by motion for summary disposition or by trial. But we give you some time to do that. The next time we're going to have you come back by Zoom would be October 27th at 2:00. So we're expecting between now and October 27th to have some discussions to figure out, can the case go away? On October 27th, I'm going to say, if it's Mr. Jamal or someone else, I'll say, Mr. Jamal, do we have an agreement? Is it going to be a dismissal or an agreement, or do we need to have a motion or a trial? And then I'll ask you the same question. So my job right now is to just make sure the case ends. I don't know how the case is going to end, and I'm going to give you enough time that you can have some conversations. Do you understand the process?
Yes.
Okay.
Hey, Your Honor, could I make a comment, please?
Well,
I'm the husband.
This is my husband of 50 years. He does he pays the bills.
I totally get that. It's
Anyway.
not that you don't have the knowledge, but you haven't been sued. So
Yeah.
you typically
exactly.
can't, but I'll listen to what you have to say.
Well, did you receive the answer on June the 10th, sir?
Yes, there was.
We answered the summons because we do have legal representation through Slate Legal Group. That particular account is enrolled in a credit relief program and has been for a year before the summons showed up.
Have but there's a difference between an attorney filing an appearance in the case and you hiring an attorney that's part of
Right.
a legal group. Those are different
Okay.
things. So you may want to contact that Slate Legal Group to follow up. Mr. Jamal may
Yes.
be interested in doing that too, if he knows about that. So I would provide you an opportunity maybe to relay that information to him, because as you can imagine, big company like Citibank, sometimes they don't always get their information all the way to the attorneys. And
Right.
so I will provide you an opportunity to chat. You're saying you've not hired somebody to represent you on this case, but that you've hired a debt consolidation company.
That is correct. Yeah. And then the day that we answered on June the 10th of this year, the court clerk faxed that or emailed it over to the attorneys, the plaintiff attorneys. And also I sent a snail mail letter about 2 weeks ago with the exact same answer. So
Okay.
I'm assuming they've gotten it, but yeah, I've contacted Slate. It's in there's a litigation attorney that's going to hopefully get a hold of the plaintiff's attorneys and get this thing settled.
Well, I will offer an opportunity for you to check back in on a settlement conference on October 27th at 2:00. The document I'm going to send you in the mail has all of the
Okay.
dates and times. Mr. Jamal,
Okay.
is there any benefit to meeting or chatting with the Tompkins prior to that date?
You know, I don't think at this time. What I would say though is we did receive their letter. We're really just waiting for Slate Legal Group, the debt settlement company, to reach out to us to give us authorization to negotiate with them. And when we do receive that, we can kind of begin discussions to try to get the matter resolved.
Okay.
Okay.
Thank you.
So it sounds like
Appreciate
it's
that.
going to, yep, sounds like it's going to be that. So October sounds like a long way off, but for legal cases, it's a heartbeat. So we'll see
Okay.
you in October. October 27th at 2:00 on Zoom. You just log on the exact same way, unless you get the case resolved, and then it may be dismissed by some kind of consent judgment or a dismissal or whatever else the case may be. But until here's bad English, but good law. An order's an order till it ain't. So you have to be here on October 27th until the case is dead. Okay?
Yes,
Okay.
thank you much, Your Honor. Appreciate it.
All right. Thank you. Thank you, Mr.
Thank you,
Jamal.
Judge. Thank you, Tompkins.
All right.
Yes.
We'll
Yep,
be in-
thank you.
Thank you. Now, calling the case of American Express versus Fernando Mendez. This is file 21-08974 GC. Counsel, identify yourself for the record.
Jeff Werber, P67124 on behalf of the plaintiff.
And Mr. Menendez, if you would please unmute yourself.
He was there.
As the name with the black box is there. Mr. Mendez, if you would please unmute yourself, and if you have the ability to turn your camera on, I would appreciate that as well. Unfortunately, we can't tell who it is that's got this black box. It's not a person, and it could be anybody putting their information in. So I'm just going to go ahead and go with the case. This was scheduled for 2:00. The time is 2:21. And Mr. Werber, the motion for summary disposition, just checking to see if maybe you received any type of answer and the court did not. I do not see an answer to the motion for summary disposition.
No, Your Honor, I did not receive a response to the motion.
Okay. It looks as if it was filed for a request for $7,222.60. And this was under a C10 and 2.116 G5. Let me just make sure that we had the affidavits. Get the affidavit of the plaintiff filed. Make sure it's signed in proper form. It is. So based on court rule 2.116 C10, the defendant would have had to file some type of answer or an affidavit in lieu of, although I could have granted under either one. I think 2.16 C10 would be appropriate. Maybe we have Mr. Fernando. Good afternoon, sir.
Hi, Fernando. I think I got disconnected from my Zoom meeting on my computer. I don't know
Okay,
if you could.
Could you tell me your name, please?
Fernando Moreira Mendes.
All right, Mr. Mendez, you're representing yourself, sir?
Yes, Honor.
Okay, today's time and date set for a pretrial as well as a motion for summary disposition. Did you get a copy of the motion for summary disposition? That would be a piece of paper that's named that.
Yes, I did.
All right. Did you file an answer to that motion for summary disposition?
I did, Your Honor.
Did you file a motion for summary answer to the complaint or the motion for summary disposition?
I don't know that, Your Honor, actually.
Part part of the problem of representing yourself, unfortunately. We got your answer to the complaint, meaning the initial document when you got
Yes,
served. We got that.
I did get the notice of hearing. That's what I got.
Okay. But there was also another set of documents. Let me share that with you so make sure that you can see it.
Yeah.
Probably on a phone, so it's going to be pretty small looking, but you see there should be a document that says notice of hearing for today.
Yep.
And then at the very top, it was called, you see how it's called here? It's called plaintiff's motion for summary disposition.
Yes, I do have that one.
Okay. But did you file an answer to this one?
I did not, Your Honor.
Okay. Can you tell me what you do for a living so I can see if I can talk in your terms instead of mine?
Yes, I am a mechanical engineer.
Okay. Well, a lot of times lawyers will joke that they went to law school because they didn't like math, and that I'd probably fit into one of those categories. So if my statements are less than perfect on my lack of math, please my apologies. But
Yes, Your Honor.
as part of mechanical engineering, you probably have to learn the laws of thermodynamics, correct?
That's correct, sir. I mean, Your Honor. Sorry.
So if you don't know how to heat transfers, even if you think you do, and I don't succumb to the law of thermodynamics, the law of thermodynamics really won't care. If I try to do a heat transfer and I'm wrong based on the math, I will just have failure. Correct?
That's right. Yeah, you have to follow the laws.
You have to follow the laws. So in my case, what had happened was that Mr. Werber or someone from his law firm filed an initial complaint. And that's the initial document that you filed an answer to, which is good and fine.
Yeah.
Then he filed another one. It's like a second problem. So if you work in a plant or whatever, it's like you may have one line that has two problems. You fix the first problem, but then there's a second problem with the machinery. He filed a second problem with the machinery that you needed to address, and you did not address that. So what he is essentially saying is, Mr. Mendez may not be able to have the money to pay for it, but we have proof that he owes this bill. So there's two parts. Is it your debt, and can you pay it? We're only talking about, is it your debt or not? And he says there's overwhelming evidence that it's his debt. He may not be able to pay it because it's too much for him and he's in financial hardship. But we've got all of these facts that show that he owes the debt. And then they filed what's called an affidavit, which means a promise under oath that these things are true. And in my world, like the law of thermodynamics, you have to answer that one too and also do an affidavit. So for example, let's say that you never had an American Express card ever, and someone stole your identity. And you would say under oath, I've never had an American Express card. I've never done that. Someone stole my identity. Here's the name of the person. Here's the police report. I promise you, Judge, I don't owe this debt. Well, I'm making that scenario up. But in this case, Mr. Werber filed a motion saying, Judge, there's no doubt that he owes the debt. And then what that does is that puts a burden on you then to answer that problem. And you didn't file an answer to that problem. And I don't know if there's an answer to that problem. There's a difference between owing the money and being able to pay. Those aren't the same things.
I do have a paper to read if you allow me to read it, Your Honor.
You have a what?
It comes from my debt resolution company. And it says, I'm currently enrolled in a debt resolution plan to resolve my total debt of $22,800 with four credits.
Hang on. Is there a way you could turn down your volume just a little bit, because you're reverberating back to us? So I want to hear you, but I don't want to hear me.
Yeah, I can hear that too. Is that better?
A little bit. I wonder if it's Mr. Werber.
Your Honor, I believe it's coming from Mr. Werber's.
Mr. Werber, can we just put you on mute for a second to see if we can knock out that? Thank you. All right, go ahead.
Okay. It says,
Yes.
I'm currently enrolled in a debt resolution plan to resolve my total debt of $22,838 with four creditors. I am trying to work out settlement agreements with my creditors to avoid bankruptcy. I have settled 2 of my 4 accounts enrolled with AmeriCorps. AmeriCorps is in active negotiations with my creditor. My financial hardship is the result of my spouse losing a job. And right after she lost the job, she also had 2 surgeries on her knee due to a cancer that she had when she was 16. The first surgery, the doctor did not correct the bone on her knees, and she had to go for a second surgeon to fix the mistake that was done on the first surgery. And then this was just before COVID. And due to unforeseen circumstances, I had to lean on credit cards to help cover my living expenses. The high interest rates have made it difficult to pay down the balances. As a result of these circumstances, I have been unable to completely pay off my balances in full, and I'm seeking financial relief.
Thank you for that.
You're welcome.
First of all, I'm very sorry to hear about your wife's cancer, and it sounds like maybe you've got the knee surgeries taken care of, hopefully, and she's on the mend.
Yes, on the second surgery, thank God it's working better.
Oh, that's really good. But here's one of my issues. I don't know if welding is in your bailiwick or not, but if I welded something with aluminum to steel and it just didn't take, even though I thought it was the best thing to do, and I did a really nice looking job, when pressure and stress comes against it, it would just break because
it's going to break. Yeah, it's not going to work.
That's the same thing as that note, because even though all of those things I believe are true, it doesn't say you don't owe the debt. What you essentially said is, hey, heads up, American Express, I might have to file bankruptcy, and they may change how they do their collection.
Mm-hmm.
But as it stands right now, I don't see a reason why I shouldn't grant Mr. Werber's company the right to try to collect it. You may still reach an agreement, but I'm going to grant his motion for summary disposition because you're not saying you don't owe the debt. You're saying you're trying to reduce the debt and you're trying to not file bankruptcy. Bankruptcy could take the whole thing out, but I don't see a reason not to grant the request. So let me unmute Mr. Werber here for just a second. Mr. Werber, I thank you because we were getting a reverberation sound like from you. I presume you want me to still make the determination on the motion for summary disposition, or would you rather have me wait and see if there's a consent judgment? I can do it either way.
No, Your Honor, I do want to move forward with the motion, and I ask that you grant it. At this point, Mr. Mendez, I haven't received a power of attorney or any communications from AmeriCorps. They haven't reached out to me. They haven't sent me anything at this point. So I'm happy to negotiate with them. But I do request that the court grants the motion and enters a judgment.
All right. So I'm going to grant the motion, Mr. Mendez. That doesn't mean that you still can't have AmeriCorps settle the agreement, but I'm going to grant it because they've asked it properly. They filed the documents appropriately. You've not responded, and that's not because you're doing anything wrong or mean or anything else. It just means you used aluminum on a steel structure. And so he's going to win the motion for summary disposition, but I would turn up the thermodynamics on your AmeriCorps to get them to talk to American Express, if I could use that phrase, because, obviously you don't want to file bankruptcy, and it always turns the stomach of anybody who's trying to collect the debt. So Mr. Werber understands that, but right now he will have the right to be able to collect it. So I'm granting his motion for summary disposition. That ends this case, but it doesn't end the negotiations towards how you pay for it. Does that make sense?
Yep.
Okay. All right, Mr. Werber, you had submitted. Did you submit
I don't believe so. If the court doesn't mind, I'll submit one under the 7-day.
All right. What that means, Mr. Mendez, is that the attorney's going to send a document to you, basically saying that they won for the amounts that they had requested. If you have an objection that it's wrong, for another reason, they'd ask for $7,000. They put $72,000. They miss a decimal. Then you would say, I object because it's not correct the way that it should be done. If you don't do anything, if it's right, you don't have to do anything, and then the order will come in place 7 days from now, or 7 days from when we receive it. If it's incorrect, if they have your name wrong, or if they've got the dollar amount wrong, or if they've got something else wrong, then you have to submit a document to the court stating your objection, and then I'll have a hearing and we'll make that determination. In the meantime, because it's going to take a little bit more than just the 7 days, I would be on the phone with AmeriCorps and spending a lot of energy there. Okay?
Okay.
All right. Thank you. We'll be adjourned on your case.
Thank you, Your Honor. Have a great day.
You do the same.
Thank you.
Did I cover the 2 o'clocks already sufficiently, Michaela?
Yes, you did, Your Honor.
All right, so we're going to go to the 2:15, calling the case of Michael Engwes versus Howden's Landscaping. If I could have counsel for plaintiffs over here at this table, and whoever's going to represent Howden's Landscaping over at this table. I guess you both could come up and we'll get it figured out.
I guess there's no way to bring representation.
Counsel, will you please identify yourself for the record?
Jim Phillips on behalf of the plaintiff, Your Honor.
All right, and from my left to my right, if you could please officially identify yourselves.
Tim Howden.
Okay.
Kenneth Howden.
All right.
I'm sorry, Your Honor, I could not hear them.
Em and Ken,
Yep.
but it's right to left instead of left to right. So he spoke up ahead of time.
He spoke first. Then.
Yeah.
I was thinking my left. Sorry, Your Honor.
So this is a show cause, correct?
It is, Your Honor.
Mr. Phillips, it's because you not received payment. Take a look here. Proof of service, show cause. Are the computers on in front of you? Because it's hard to read it from the computer screen. So what I'm going to do is pop it on. I'm going to pop it on screen so you can see it real close. So take a look here. Should be there, but when that pops up, you should see it too. That's not it. That's it right there.
Yeah.
Okay. So Tim and Ken, I'm guessing, since you're Howden's Landscaping, with Ken being the agent, so we'll chat with Ken in just a minute, that this is a document I may want to explain. What happens is when things aren't being done pursuant to a court order, the people who want to get the benefit of the court order can ask the judge to send out a notice for show cause. And show cause, if I kind of put it down to more layman's terms, just says, tell me why you shouldn't be in trouble. That's what it means. Show me a reason why you shouldn't be in trouble, because the document will say, I told you to do something, you didn't do it. So let me show this to you so you can see where we're looking at here.
Yeah.
So in this document, you see it has numbers, and that's how it works here. It says the attorney for the plaintiff, which is Mr. Phillips, has failed to comply with an order dated 3/11/2021, and Ken Howden, so because you're the agent, in a civil, why you shouldn't be found in civil contempt because of an order that was submitted. And that's, see if we can find that order so we can show it to you. Failed to comply with the order dated March 11th. So there was an order on March 11th, and let me find that order so you can see that one. Here we go. Looks like a discovery request, Mr. Phillips, is what it was. Okay. So. So Mr. Engwes and Elizabeth Engwes had asked for a subpoena, and a subpoena is an order by the court that says they wanted you to testify at a hearing on April the 27th at 11 a.m., bring your personal and business records pertaining to income over the last 12 months, including tax returns for 2019 and 2020, federal and state, and all contracts and accounts receivable, all passbooks, checkbooks, and names of all banks in which accounts are being held, titles to vehicles, and the like. And you were ordered to do that. Failure to obey the commands of the subpoena or to appear at the stated time and place may subject you to penalty for contempt of court. That's why you're here today. So, Mr. Phillips, what is the judgment amount in this case?
Including the cost of this show cause and the service of this show cause, it's $39,1647.
$3,916.47. So one of the benefits of coming to court and sitting and listening to everybody else go through their cases is that you can kind of hear how the structure goes. In the cases before your case, it was all about that first phase. Do you owe the money or don't you owe the money? And you may disagree that you should owe the money or not, but there is some place of judgment that says you do. So for the court's purposes, that part's over. The second part is try to collect it. You guys are in the you're in a business of providing services. So sometimes when people don't pay you, you try to figure out how to do that. The inguises who got a judgment against you, and again, I'm not challenging the validity of the judgment. I'm saying there was money that was owed. Then there's different ways they can go about it. The first thing they try to do is figure out where your bank accounts are. And so they have a right, just like you would with your customers if somebody didn't pay you. If you got a judgment, small claims, you could then ask the judge to say, bring all your banking documents, because guess what? They're going to probably file a judgment in a document with the courts to take the money out of your checking accounts. And so they filed the document saying we wanted to do a garnishment. It's probably what you want to do. They don't tell you that. They just said, I just want to know where all your stuff is. And then guess what? After they know where all your stuff is, there's probably going to be a garnishment. Well, that was a court order saying you better do that. That was like me saying you're going to do that. And so like when you don't do it, it's like you giving me the middle finger. And that's why Mr. Phillips then says, well, judge, have them explain why they shouldn't be held in contempt of court. Civil contempt and there's criminal contempt. Civil contempt, criminal contempt is punishable by up to 93 days in jail and up to $7,500 in fines plus court costs. Civil contempt, like could make you go to jail until you produce the documents. Usually we don't do that. Usually we go, can you produce the documents? Ultimately, they want to be paid. Obviously, if you paid them, you wouldn't have to disclose all of your information, which you probably don't want to do. So is there a reason why, and there might be, there was a reason why you didn't provide all the documents that were ordered that you provide? And I'm just talking to Ken now because he's the registered agent. That's the benefit he gets by being the man.
Okay, Your Honor, well, it's a 50-50 company.
I know, but
He
one
takes
person
care of
gets
the
picked.
landscaping, Yep.
Yeah.
I do the other part. I guess it was miscommunication.
Your brains
on
and
our
he's
part.
brawn, right? Well, I don't want
No.
to say that in front of the brothers here, but
He does the landscape and I do the other half.
okay.
Okay. And I guess it was just one big miscommunication between both of us on the whole thing. And the one part we didn't even get in the mail until 2 days after the court date.
Okay.
And I guess
Well,
I'm confused on the whole
there's
thing. So
there's a couple things that can be done now. I mean, and you're in the landscaping business. Do you do all types of landscape, or you do just mowing, or you do just digging, or
everything.
everything? Okay.
Except fertilizing and spraying. Your Honor.
Except for fertilizing. That was my analogy I was going to go with, but I'm going to use it because you guys would know more than me. I used to try to fertilize my own yard, and the fertilizer and the grass, it just doesn't care whether I stop for half a second and it drops a lot more than what I want, or it gets all gummed up when I try to use one of those cheap things and it burns my grass, even though I didn't want it to, even though I thought I bought the right stuff, or if I bought the wrong stuff, the grass doesn't care. The grass cares about, and the weeds care about having it done properly. In this particular case, you were ordered to do that. Now, there's a couple ways we can do it. I don't know what your plan is. I don't know, and I'm not going to, on the record, get into all of those things. But Mr. Phillips has a right to be able to have some of that information. You can, if you have the ability to pay off the judgment, you don't have to provide any of that information, because ultimately, Mr. Phillips, you just want the money, right? You don't care where his banking account is and what his titles are to his vehicles or anything else.
That is correct.
So I think we got your attention.
Yes.
And I think if we set another date where you can come back and provide all that information, which will be 2 weeks from today's date, you now have a target. Okay. You can bring in all the information regarding your tax returns and titles to your vehicles and everything else that he's requested, or pay off the debt. But you got to do one or the other, or reach a payment plan. There might be a payment plan that the Inglisses might be willing to do, and that's between you and Mr. Phillips. You guys can chat. We got rooms over here. You can chat for a few minutes to see if he'd obviously have to get permission from his client. But Katrina, can I have Michaela, I guess this would be on Magistrate Ladwig's docket probably, wouldn't it?
Correct, Your Honor. If we're going to reschedule another discovery hearing.
Well, I'm going to discovery hearing. Give me the date and time.
They are still being done by Zoom, unless you want me to schedule that one specifically in person.
Well, we could do it by Zoom.
We are going to do August 10th at 11 o'clock.
All right, so August 10th at 11 o'clock, you got to provide all that documentation unless you reach an agreement with Mr. Phillips and his client. And I've used this already today, but I'll use it again because you may not have been here. Order's an order till it ain't. So you have to show up unless you paid it. If you paid it, Mr. Phillips signs maybe they do a satisfaction of judgment, maybe they do whatever. There's a lot of creative ways to make this go away. So you may have a chat with Mr. Phillips. You're all here right now. You wouldn't have to do it on the record where we're sending it out by YouTube and out into the public in front of everyone else here. We have plenty of spaces if you want to take a couple of minutes and chat before you leave. Otherwise, August 11th at 11 o'clock. And what I have you do is go over to the civil window and just pick up your notice. That way you don't have to worry about it. We don't have to mail it. You have it. Michaela, can you have that ready for Mr. Howden?
Yes, Your Honor.
Okay. Mr. Phillips, anything else?
No, that's fine. We'll take a few minutes and talk.
I think you probably can reach some kind of an agreement. So now, Mr. Ken Howden, now you know the detriment of being the 50-50 and being the resident agent. Maybe you guys flip a coin over who gets to be at each year, but
On the paperwork.
yeah. All right. We're all set. Thank you.
Can I say
I'm going to
something?
determine the
Can I-
show cause has
No, I
been
just wanted to
satisfied.
say, when you were talking about the 427 one, I had talked to a lady that day at the courthouse
Oh, yeah, 'cause
about
we were on
that.
quarantine.
Yeah, because his wife and my girlfriend worked together, and
Okay.
everybody was in quarantine from that.
Okay.
And then they said they were going to reschedule it, and then
And we did send out notices.
When was the other?
that's the one where
That's
he
the one
got
we got 2 days after the court date.
I'm not going to try to throw the mail under the bus because they've done a lot of work, but that's the reason why I want you to go pick it up now, because we can send it back out again, but I'm not certain how well things are getting done through the mail. So,
Well, we wouldn't even be here. I guess I sent all the stuff back when this originally started and never heard nothing back until they set a judgment against us or whatever.
okay.
And
Well,
they said they never received nothing.
unfortunately, that's kind of where we're at. So we're all set for today. If you can use any of the rooms out in the hallways, a pretty nice size with tables and everything.
Okay.
All right.
Your
Thank
Honor.
you.